So everyone, welcome to our first session for today and the fourth session in all, Old Faiths, New Challenges. And our first speaker today is Veronika Ondrášková from the Masaryk University Faculty of Law, and she will speak about the agenda of the Corrector of the Clergy in the Diocese of Prague and its secular equivalent. Veronika, the floor is yours.
Thank you very much. I hope the sound is all right. I will try to share my presentation, and I hope that that will work. So, is it working?
Yes, we can see it.
Okay. And is it possible to do it full screen? Yes. Very well. Then, honorable professors, ladies and gentlemen, I do in fact come from Masaryk University, the Czech Republic, and today I would like to speak about the legal aspects of the Corrector of the Clergy, of the agenda of the Corrector of the Clergy within the Diocese of Prague at the beginning of 15th century. I divided my presentation and this little speech into two parts. So first, I will introduce the office. I will talk about the foundation of the institution of the judge and its position within the Diocese of Prague and why I chose the topic. And second and most important part, we'll be focusing on the legal aspects of some of the parts of the agenda, which I chose to be the moral delicts. Because it was the majority of cases that occurred in front of the judge were moral delicts. So that's why I'm focusing on the breach of celibate, on playing dice, visiting taverns, etc. And I will be comparing the legal rule that was set by a church at first for the punishments that were prescribed for the moral delicts, and I'll be comparing it to the actual agenda of the judge and to the case law, and we'll see how that goes and how that went at the beginning of 15th century. So just a very, very quick remark on the foundation of the office. So the corrector, as I said, was a judge. He was a criminal judge only and solemnly for the clergy, and he also supervised the morals. It is the office that was founded by the first archbishop in half of 14th century. And unlike the other judicial institution that existed in the ecclesial administrative structure at the time, such as the officials, the general vicarage, possibly inquisition, the corrector of the clergy was a unique institution, meaning it wasn't constituted in any other region of Europe, because these that I spoke about, the officials, the general vicarage, they have its origin in France, for example. So this is just a unique institution that was solemnly created in Prague. And now the question would be why there was a need to constitute another judicial institution when we already had 3 or 4. Well, apart from the question of supervising morals, the answer may be more political one, because the Diocese of Prague was divided into 10 archdeaconries, and each of the archdeacons had their own judicial power over the smaller units. And unlike the officials, the general vicarage, they did not derive their power from the archbishop directly, but rather from the benefice they held. And so by creating this institution, the archbishop, who had very, very limited power over naming the archdeacons, he submitted the agenda to the corrector of the clergy. So now the archdeacons had to report the visitations to the corrector, and he was the one making the final judgment. So that might be one of the reasons. But just for now, to remember, it was a judicial institution and a criminal judge. Unfortunately, we don't have many source material that would describe the agenda of the judge, but we have only one judicial book that was preserved, and that is why I based my research upon the beginning of 15th century, because this book is from the years 1407 to 1410. So I analyzed different cases from the book. That's over 500 of them. And just to be clear, as I said, I'll be talking about the breach of celibate and the moral delicts as such, including playing dice, for example. but just so you can visualize and see the proportionality of the cases at the time, I made this graph so you can see that actually there was some criminal agenda, although only in around 10% was theft, robbery, a few cases of murder from the clerics, but most of all it was more of procedural acts and that's etc. etc. But I'll be talking about the breach of celibate and the moral delicts. As I said before, I will be comparing the legal rule of the church that was issued by the archbishop at the beginning of 15th century by statutes, and which said that all of the clerics of whichever status have to immediately expel all concubines and prostitutes from the rectories and neighborhood, and the punishment was excommunication and prison. Now, before I get to the punishment itself, I want to talk about two more aspects, and the first, which are highlighted here. And the first one is the status question, because now we need to understand that it was prescribed for the higher ordinations to remain celibate, and that were subdeacons, deacons, priests, and possibly bishops. But because bishop was higher in the hierarchy than the corrector of the clergy, we naturally don't have any cases that were judging bishops. The majority or all of them are to be priests in the book. So here the question again might be why there are not any subdeacons and deacons, but that would be for another submission. So I'll just move to another important aspect, and that is the immediate expel, because another rule that was set later by church actually said that it has to be done within 6 days. So the church gave the period of 6 days to get rid of the women from the rectories. And because I didn't really have much time to spare, I will just spoil this to you and say that from around 200 cases, in 40, there had been a period set, and only in one case, the period followed this rule and was set under 6 days. Usually it was more prescribed in months or from 10 to 20 days. So just so you get the image. And now to the question of punishment, it was later also added that it has to be also withdrawal of benefits, which was sufficient for the priests because they derived their income from the benefits they held. And also the excommunication was set for playing dice also. So just now to keep in mind that the punishment was excommunication and withdrawal of benefits. And now is my favorite part, because I have shown you the graph to visualize the proportionality. I spoke about the legal rule, and now more to the numbers. So from between 1407 and 1410, there had been over 223 cases that were investigating celibate, the breach of celibate. And how many of these cases would you say that actually got the excommunication sentence or the withdrawal of benefits? It is true that not all of them were sentenced. Some of them were just investigated when the corrector found that they were, let's say, innocent and the sentence wasn't made, but in majority of cases it was. So how many of these numbers would you naturally say received the excommunication? Well, I'm going to say it. It was just one case. It was one to rule them all, the one hero that managed to get himself excommunicated. And I will talk about him because his story is quite funny. But so you get the idea that the corrector didn't really follow the rule. And in all of the cases, except one, the punishment was set to conditional sentence, meaning he said, well, all right, now you have here the woman, now get rid of her, or you have to pay fine or go to prison. See, it wasn't, even the conditional punishment wasn't set to excommunication. It was, to be fair, only 5%. And these 5% were more of severe breaches of the norm. And I'll be talking about these cases, of course. But just so you know, that the majority of cases receive only fine or prison sentence, and it was only conditional, meaning if they come back again in front of the judge, they'll have to pay the money. In 1%, it was withdrawal of benefits, so really not very severe. To be fair, in 46% it was set to prison, as I said, because sometimes it was combined, it was rather prison and excommunication or prison and fine. But I have to say that the priests were usually held in a prison for days, yes, 1 or 2 days. Sometimes they were released even the same day they were imprisoned. So the judge wasn't really hard on giving the sentences. And I also mentioned the recidivism. It's not easy to conclude the exact number of the priests that that came in front of the judge again. But let's say, but the point is, it would seem that once they come back, once they were investigated again, they would receive the punishment that was prescribed for them in the first time, right? But it's actually not true, because not even half of these people received the punishment that was prescribed. The corrector more often said, well, okay, again, please get rid of the woman or you will be... And now the punishment was conditional, but was more severe. So it got more severe, but he wasn't really punished. It was usually only until third time when they really received the fine, and they didn't even really pay the whole fine, usually only just parts of it. But I'll be talking about the recidivism in the case law, which is just now. So to some of my favorite protagonists of the books, the first one is the hero who managed to get himself excommunicated for the very first time, and he is the only case that managed to do so, and who actually followed, to whom the corrector followed the rule prescribed by the church, which was excommunication. And what he did, well, he was caught with the women right in church, which meant the desecration, the violation of the holy place. So not only had he been excommunicated, but he also had to pay for the resecration or the reordination of the church, because unless that would be done, there couldn't be conducted any rituals, any prayers, etc. So he had to pay for the reordination. So if you were wondering what did it take to be excommunicated from the Diocese of Prague or from Prague for 1 year, this is the case. There was actually also another one that managed to get a prison sentence right away. It wasn't excommunication, it wasn't withdrawal benefits, he was just straight sent to prison. And the reason for that is because the corrector found that he had a concubine 7 years and he had 5 children with her. So this was considered a severe breach, I would say, and he was sent to prison. But don't get fooled, because he was released in 3 days. So the prison sentence served more as a information case. It wasn't really, as we can see, to punish them, because the corrector wasn't really severe on that one. I also spoke about cases, about the 5% of the cases that got the conditional excommunication, because the cases I spoke about before are really a rarity. It didn't really happen at all. The majority got the conditional sentence. And now the question would be, what was also a severe breach for them to receive excommunication for the first time, or the conditional excommunication? So this priest from Čáslav, he was caught with married women, and in general, I can say that once the priest had encounters with married women, they would receive more severe fine. So this was the rule. But also they were caught at the cemetery, which was, to be fair, quite popular place for this for the meetings of the priests with women, because several cases and that refer to this merits. And this is what managed to get him the conditional excommunication. So this was also considered to be severe breach. In other cases, the priest held the concubines at their rectories or homes. So the corrector usually for that ordered to give them the conditional fine. And the last case that I chose it for a very specific reason, to demonstrate the question and the problem of recidivism, the recidivists. Because this priest from Slana, we meet him for the first time in 1407, when he arrives drunk in front of the judge. So he's sent to prison straight away. He's released the next day and told not to play dice, not to visit taverns, under the conditional sentence of prison. So half a year goes by, we meet him again, and he's asked if he committed any theft, if he had visited any brothels, played some dice, visited taverns, and he said, well, I didn't steal anything, but I admit to the latter. And now we would expect that the corrector would send him to prison, right? But he didn't. He gave him another conditional sentence. He said, well, okay, stop doing this, please, or you will go to prison. So it is not much surprise we meet him for third, fourth, and fifth time. And for the fifth time, he receives a fine and goes to prison. And it isn't clear how long did he stay there, but he had to pay the fine, which was quite high for the priest. But this didn't stop him because he comes back for the sixth time, and finally he receives the excommunication. But mind me, it's again only conditional. So not even when the norm said that they would be excommunicated if they visited taverns, this one breached the norm 6 times and still didn't manage to get himself excommunicated. So just to wrap this up, I tried to introduce a unique institution of the judge of the clergy that was constituted solemnly for Prague, which I found interesting, and I've been focusing on the case law, and I presented that the corrector didn't really follow the legal rule of the church, and that the institution was actually quite benevolent towards the priests and towards the given punishment. So I thank you very much for your attention, and if any questions arises, then I'll be more than happy to answer them. Thank you again.
Thank you very much, Veronika. I'm sure there will be questions when we get to the discussion. We do have a hand raised, but if you don't mind, the discussion is after all 4 presentations in the session, so there will be questions, obviously. And our next presenter from today is Agata Nawacka from the University of Warsaw College of Interdisciplinary Individual Studies in Humanities and Social Sciences, and her presentation is Between Freedom and Duty, How the Jewish Law of Obligations Merged Both. Agata, please go ahead.
First of all, thank you for accepting my contact and my abstract, and I'm really happy to be here with you, especially after the lecture, which addressed some of the issues I also want to talk about at my presentation. First, let me establish, and I will count 15 minutes to be in the exact time, and I'll start to share the screen. Can you see the presentation? It's the title page. Great.
Yes, it works.
Yes. So the subject Between Freedom and Duty is an actual result of 2 conversations I had in the last few months. One with the Chief Rabbi of Poland, Michael Schodrich, and the second one with Professor Michael Broy, the specialist in Jewish law of obligations at Emory University in New York. My first idea was to make a presentation and some research on the case of the breach of a contract in an extreme change of circumstances in Jewish law. However, imagine how surprised I was when Professor Broy told me that there is no such thing as a contract of this type in Jewish law. So I decided that this matter deserves another research because it has not been pretty much developed in the continental legal philosophy. And I think it's really important to know how our religious assumptions shape the law around us in the states that do not claim to be religious nowadays. So the first most important thing about Jewish law is the fact that it has a theological origin, and Judaism does not know a strict distinction between the sacrum and profanum, as we know in Christianity. I will say the Western perspective is a short term for common law and civil law of Western Europe, because it is the most well-known and influential legal systems currently. So I will use the term Western law and Jewish law. So it is believed that Moses received all the law, present and future, in the words of Torah, with all its future interpretations. It was given to him by God and Mount Sinai. And this created an obligation between God and Moses and all of his descendants. If Moses believes in the only God with whom he made the covenant and will circumcise his male descendants, and his descendants will do the same, the contract will live on. And thus, the Sinaitic covenant is a central part of Jewish identity. To be a Jew is to be bound by the covenant and to fulfill its promises. Therefore, we can see that duty plays a central role in the Jewish thinking of life and the social status of a person. Because when we think of what it means to be a part of some religious movement, we usually think of some religious duties. However, in Judaism, religious duties are also legal because the covenant is both moral, legal, and religiously binding. So the covenant also played a significant role in preserving Jewish identity throughout 1900 years of the Jewish community, which did not have a state. So it was an interesting example of how a very complex legal system could develop and flourish even without a sovereign. And the Jewish identity revolves around the idea of a mitzvah, which is a word for incumbent obligation. A man's or a woman's place in a society is shaped by the obligations he or she has. It's a different way of thinking than the Western one, which is more concerned with rights. For example, I have a right to privacy. The Jews would rather say that it's not their actual right, it's the duty for the others not to interfere into my sphere of privacy. It's the same thing, but it's called in a different way. And it's important to remember that the most important celebrations in Jewish rituals mark the acquisition of new responsibilities. When we may think of a very common idea to celebrate the rite of passage into adulthood, for example, 18th birthday in most of the countries, the Westerners usually think of the acquisition of rights. The right, for example, to drink alcohol legally, the right to drive a car, maybe not simultaneously, but it's still about the not being bound by additional obligations that are put into children. However, the Jewish logic is that the duties show the man's place and his relation to God, and thus the acquisition of duties is a reason to celebrate, as we can see in bar or bat mitzvah, which literally means the son or daughter of obligations. When a boy reaches 13 years, he goes through a ritual which makes him a mature person. And what maturity means in Judaism? It means being able to fulfill every commandment, every one of the 613 rights and obligations that are contained in the Torah. So it's very important to remember that the obligation is ground for individual responsibility. The individual does not think whether another person has committed something wrongful to him or her. He or she thinks how we can address it and thus be morally responsible for one's own actions. We can see this, how a dense network of duties shape the idea of an obligation in a Jewish law halacha. An obligation is thought to be a debt which must be paid off. It's a different understanding than the so-called Western one, when an obligation is created by an exchange of promises and is a result of individual freedom. In a Jewish law, obligation is considered to be a debt, and thus duties precede obligations. And to fulfill a contract is to pay off a debt. This also means that obligations are strictly delayed to the moments when a so-called kinyan happens. Kinyan may differ from one transaction to another one, and it's the only way to make a legal promise binding. Let's see it on an example. Let's take merchandise, for example, one of the simplest ideas of a contract. Let's assume that I would like to sell the flowers that are behind me to one of the listeners. We agree to sell the item, we agree on the price. The buyer promises to purchase those very flowers at the price we discussed, and I promise that I will sell the item, and we have witnesses. However, it's not enough in Jewish law to make a binding obligation. We need a kinyan, a formal act of acquisition. We need to actually transfer those flowers, transfer the property to the buyer, and then transfer the property of money to me. And only after that we can say that an obligation happened. But why is it so? Why are promises not legally enforceable even if they have witnesses? Well, it is based on another foundation of Jewish thinking of the law. It's the Jewish anthropology and the idea of freedom. And however contrary it may seem to the idea that an individual is bound by many duties around him, the idea of freedom is defined as the not being bound by obligations. Halakhic and religious obligations are excluded because there is no man, there is no Jew without those obligations. Those obligations show us the place in a society, and they also regulate the attitude of a person to God and to himself. So they are crucial for personal identity. However, every obligation with another human being, let's say that's a bilateral obligation, an obligation made by people to people, is a threat to freedom, because rabbis in Talmud believed that contracting individuals' future choices away is a negation of freedom. If let's take the example of the merchandise of flowers. If I promise to sell the flowers and one of you promises to buy those flowers, we only exchanged words. And until we actually meet, and I will give you those flowers and you will give me the money, we can say that only words bind us. And in Jewish Talmudic tradition, it is said to limit the freedom in an unacceptable way, because actually nothing happened. We exchanged promises. If any one of us breaks our promise, it is morally and religiously condemned. However, it is not legally enforceable. And the so-called Western tradition also knows promises that are which breach is morally and socially condemned, but may not be legally enforceable. Take engagement, for example. In many countries, it's not a legal institution. However, we would definitely agree that the breach of engagement with, for example, my fiancé would be morally questionable, because there is a moral duty to fulfill one's promises. It can be found both in the Torah and in the New Testament, and both Christianity and Judaism adhere to that principle, to not tell lies, and the breach of contract is a lie. So an agreement to perform does not create a legally binding obligation. And now let's move to what we may call the Western idea of a contract, and the idea of freedom of contract rather than freedom from contract, what my Professor Michael Broyd accurately described about Jewish law of obligations. I put together three, and here in a few minutes there will be another four image of what I suppose are the most important makers of the modern Western thinking of contracts. And the lecture at the beginning of this panel was extremely helpful because it actually touches the same matter. First, let's start with David Hume. He may not be the first one to say it, however, he was one of the most influential thinkers which presented the idea of individual freedom and autonomy into the moral and legal systems of both continental civil law and common law. His idea that the individual has innate natural freedom and thus the possibility to contract away his or her future choices makes the basis of modern thinking of freedom of contract. We might have seen some of those ideas in a very early stage in the Roman law, which was more contract-driven than the law in the medieval ages. However, it was not freedom of contract as we currently understand it, because it was strictly limited by natural law rules and subjectivity. The second most important factor of the development of modern contract law is the social contract theory. I picture the cover of Hobbes' Leviathan. However, every social contract theorist, when we don't take the differences between them into account, can agree on the basic principle that the contract is a result of individuals' natural free will, and the state comes after the contract. First, the individuals agree to transfer some of their natural rights, natural ability to shape their reality with words, and thus create legally binding promises to a sovereign. So the contract comes before the state. Jewish law did not need the social contract theory because it believes in an theological origin of law. And the third most important factor in the civil law is the canon law, largely inspired by the interpretation of Roman law, which however happens after 11th, 12th century, after the rediscovery of some most important Roman law materials. And the canon law derived the legal enforcement on promises from the biblical duty to keep one's word. And the canonists also created what we now call the pacta sunt servanda standard, which puts also a legal obligation to fulfill a promise, which is not so we also add a legal obligation and enforceability to a moral obligation. And a very similar thing happened in the common law. After the Puritan Revolution, the concept of absolute obligation gained momentum because the Puritans believed that some of the decisions to nullify contracts or to keep them made by the chancellors before the Puritan revolutions were arbitrary. And the belief in the natura corrupta of a human being and its natural proneness to make bad choices required the strengthening of legal bounding of a mere world contract. So they introduced the concept of absolute obligation. So to sum things up, we may see that there are two different traditions of looking at contract, the so-called freedom of contract and freedom from contract. In one of them, free will is the condition upon which the freedom of contract emerges. On the other one, freedom of contract is not possible because it would limit one's personal freedom and thus religious responsibility. Contractual freedom is, in the so-called Western tradition, understood as the ability to make binding obligation through an exchange of promises. In Jewish law, it is believed to limit the freedom too much. This is why not every promise is enforceable in Jewish law of obligations, and the origin of obligation is always a debt, a mitzvah, which plays a grounding role for this system. So, thank you for your attention. If you have any questions or would like to discuss this subject, I would be more than happy to receive some information from you and to talk about it. And here are the links to the pictures used. Thank you.
Thank you very much, Agata, for a very interesting presentation. I'm sure there will be questions, but we move on now for our third speaker in the session, Alexis Odemal from the University of Lille Center for Judicial History, and his subject is the impact of the Merchant's Confession in the development of business law during the Siglo de Oro, the Thomas de Mercado and Martin de Azpilcueta's casuistic approach to commercial law. Alexis, go ahead.
First of all, thank you very much to give me this opportunity to present such a paper. I'm very pleased to be here. I will talk now about the 16th century in Spain specifically. As in the 16th century, the Council of Trent established the obligation for the faithful of the Roman Catholic Church, obviously, to make an annual confession at Easter. Nevertheless, in the Spain of the Siglo de Oro, the century of gold, which is the 16th century, the confessor and the merchant already had a privileged relationship. Martin de Azpilcueta, one of my key authors, gives us a practical explanation of what confession is. It is a secret and vocal accusation of the sinner of his own sins to the priestly authority, the confessor, so that he may absolve him by the sacrament. So logically, confession involves a confessor because it is his task to listen to the penitent and then to disclose the moral rules that should be applied in the situation presented to him. But the confessor is not detached from the factual circumstances, as he must also show, in the light of the factual circumstances presented to him by the penitent, how the rule should have been applied in that specific situation, and how it should be applied in the future. So, if the penance shows regrets for having offended God, which is called contrition, if he respects the confessor prescriptions developed in the confession, and if he repairs the damage done, which is called restitution, and by this I also mean by ending the sin, then he can obtain absolution and gain the salvation of his soul. Therefore, the role of the confessor is to guide the penant toward the salvation of his soul. But when the confession of a penitent raises questions, difficult and problematics, these issues are called cases of conscience, which, according to the definition given by Marie-France Renou-Zagamé, reveal a situation in which the implementation of the rules supposedly applied in everyday social and economic relations gives rise to doubts, questions, with the aim of saving the soul of the penitent, whatever his social condition and professional activity might be. So, in an effort to harmonize the response given by confessors to penitents, as the Church is used to, casuistic literature appeared, which is a literature relating to the study of cases of conscience, in the form of manuals for confessors and penitents. These books, which present cases taken directly from questions asked to theologians and confessors, are written both in Latin for the clergy as a methodological guide, to be used all over Europe, but also in the vernacular language, so that penitents, who are obviously not natives, can also find the legal rules to be applied in everyday commercial practices without necessarily have to go to the confessional. So these books reveal the eminently practical aspects of casuistic literature because the authors found their inspiration for their reflections in the reality of the confessional itself. So even if rules are formulated in a general way, they are the conclusion of studies that were carried outside of book in a long-term time in the secrecy of the confessional. Although existing since the Middle Ages, casuistic literature found a new lease of life in the Catholic Counter-Reformation, and especially in Spain, because Spain at this time was a privileged territory of the Roman Catholic Church faith, a truth linked to its long history of military Catholicism. Also, the marriage of Isabella of Castilla and Ferdinand of Aragon marks the unification of Spain with an S. The victory over the Caliphate of Al-Andalus in 1492 put an end to a conflict that had lasted several centuries. So now Spain, with no S in the singular form, became a unified territory, only Catholic, and with an imperialist vocation due to the recent arrival of Christopher Columbus in America. So 1492 is the date when the last land of Western Europe, Spain, became the center of a world economic activity as a gateway to a new world. And Sevilla concentrated the monopoly of all transatlantic trade at the beginning and gathered all the merchants leading the trade with Western Indies. So that is why the 16th century in Spain is called the Siglo de Oro, the century of gold. But this political and economical flourishment was accompanied by an intellectual development within the University of Salamanca, which in the copy I was in spoken use, so I'll be quite short here. The authors of the School of Salamanca, a current of thought based on the scholastic method, published works of casuistry, among other works, of course, with the aim to legitimize the new economic order of things by ensuring a morally acceptable and responsible practice of commercial activity. Through a detailed study of the private institutions and of the new legal tools available to business people in order to correspond to the Christian ideal of justice and to ensure the salvation of the souls of business people. So during the 16th century, the casuistic works of the Spanish theologians of the School of Salamanca became the main casuistic literature of the Catholic world, intimately blending law and religion, but also it became the figurehead of the leadership of conscience against the growing Protestantism of other nations. In this sense, two works of the School of Salamanca are of particular interest for us. Firstly, the Manual de Confesores y Penitentes by Martin de Azpilicueta, which I already quoted you at the beginning. It was published in definitive edition version in Salamanca in 1556 in Spanish language, but its Latin version, which arrived a decade later, was widely distributed all over Europe. And the second book is the Suma de Tratos y Contratos de Mercaderes y Talapantes by Tomás de Mercado, published in 1569 in Salamanca, in Spanish language too. And the specificity of this treatise is that it derives directly from the study of contracts related to the trade with the Western Indies, because the source of Tomás de Mercado's casuistry is directly the confession of the merchants of the Consulado de Mercaderes de Sevilla, so the very same merchants that were trading with the Indies, who commissioned especially the book to Tomás de Mercado. So we can see that the context of the confession has a direct impact on the writings of the confessor. The question arises as how the confession of the penitent, in all its specificities, can influence the juridical treatment of the case of conscience by the confessor, and thus form the casuistic literature to be. First things first, we have to say that the confessor is both a theologian and a jurist. First of all, confession and law are based on the same assumption, that every similar case should be treated in a similar way. So the religious ritual of confession is linked to the legal ritual of trial, for both involve a similar ceremonial. The conscience is the accuser, the sinner the accused, and the confessor is the judge. This absolution then takes the form of a judgment and the act of penance, that of a punishment. This judicial analogy of confession is found directly in Martin de Azpilicueta's book. The confessor has, by his priesthood, jurisdiction to confess and power to absolve. In this sense, the activity of the confessor is truly judicial, and the comparison with the judge is quite obvious, as Martin de Azpilicueta does it himself. I quote, "The confessor must search the conscience of the sinner as the doctor the illness of the sick, and the judge the cause of the offender." Secondly, religion shares with law its authority through the trust that it's placed in the sources of law. So either written directly installed by God, or drawn from the knowledge of someone who embodies law through his knowledge of customs, laws, canons, etc., etc. The confessor corresponds to this second category, because, as Azpilicueta states, the confessor's knowledge must contain both ecclesiastical and secular norms in order to be able to judge both the character of a sin, if he is mortal or venial, and the licitness of a contract. So the penitent, merchant, understands and learns the law from the mouth of the confessor when it dictates to him the moral precept derived from Christian morality that should govern the conduct of business. For his part, the confessor grants absolution to the merchant who practices a morally responsible commercial activity. That's why the merchant has to choose his confessor wisely, as Tomás de Mercado claims it. the penitent merchant must, in order to ensure the salvation of his soul, because he cannot himself judge his own sins or claim a knowledge of legal institution, he must choose a prudent, wise, and free confessor who is well versed in commercial practices. Thomas de Mercado also emphasizes that even if the casuistic literature provides answers to the mentioned questions, it is still up to the confessor, who is an expert in the business and understands the practice, to judge its application. Therefore, the confessor remains indispensable to the penitent, even when the penitent is well versed in casuistic literature. On the contrary, it is as important for the penitent as it is for the confessor's soul that the merchant chooses a confessor with whom he can speak freely of his commercial practices to reveal his conscience. Because, as Martin de Aspilcueta states, the confessor commits a mortal sin if he does not judge correctly the licitness of a contract because he lacks sufficient knowledge. Therefore, ignorance of the rule of law, canonical or ecclesiastical or secular law, does not excuse the confessor who commits a sin. But still, because the confessor obviously can't know everything, he is allowed to do it, and he must be able to do it. According to Martin de Aspilcueta, once again, in order for the confessor's knowledge to be perfect, he must also know how to doubt and then seek advice by presenting the case of conscience to another cleric. This consultation, therefore, can also take place through the confessional itself, where the confessor comes to ask for absolution for his ignorance, since, as I just say, he commits a sin. Nevertheless, Thomas de Mercado raises the question of when the confessor should force the merchant to follow his opinion and when he should not. The case of conscience arises in the situation where the merchant himself provides a well-sourced solution to his own problem, his own case of conscience. In that case, the confessor is free to advise his penitent to follow the most certain opinion or the most suitable for the merchant, when this opinion is sustained by enough authors and conforms to reason, because it is called the most probable opinion. It means that, I repeat, in order to be probable, an opinion must either be the fruit of a solid argument of reason or be supported by a great authority, which means other theologians in others' casuistic literature books. This reasoning is called probabilism, which, according to Wim de Kock, is defined as a system for resolving cases of conscience that distinguishes between probable and improbable opinions for the purpose of judging the lawfulness of a behavior. Thus, an opinion should not be considered as law, since they are equally probable contrary opinions supported by other theologians. Therefore, it is up to the theologian, as Thomas de Mercado claims it, and by this word I also mean the confessor, who deals with the practical case of conscience, to determine which opinion to follow and which opinion to reject, according to his own knowledge and faculty of judgment. So, in addition to pronouncing absolution, the confessor enforces a legal opinion on his own authority, committing both his soul and that of the penitent to the resolution of a specific case of conscience. Therefore, the opinion formulated in the casuistic literature of theologian is obviously not in itself binding, because there are other contrary opinions that are equally probable in the casuistic literature itself. Practically, it is up to the confessor to determine the advice he will give to his penitent for the resolution of this case of conscience, but also in the overall conduct of his affairs, for the purpose of respecting and ensuring the observance of Christian morality. The manuals for confessors and penitents are not intended, of course, to replace confession, but only to divulge the general rule, which is sometimes still subject to discussion, as I just explained, so that the confessor can apply it to a concrete situation. Thank you for listening to me, and I'll be very pleased to answer any of your questions.
Thank you very much, Alexis. This was also a very interesting presentation. And we move on for our final speaker for this session. That is Sarah Kelly Limão Papa from the Federal University of Ceará Faculty of Law. And her subject is the legal status of non-converted indigenous peoples in Portuguese America from the 16th to the 18th centuries. Sarah, go ahead.
My name is Sarah. I'm from Brazil, and I have a paper. I want to my presentation is an overview on a paper, and this paper is an ongoing research, so it's more like a project of a research that I'm working on. So I don't have all the conclusions yet, but this paper, this presentation, I'm to offer an overview of
I'm starting
my
to
paper.
share it now.
Yeah.
You'll just have to tell me when to move the slides.
Okay. So my paper is attempt to understand what was the legal status of indigenous people in Portuguese America that were not submitted to the catechesis, the missionaries regime that other people talk today about it. I think Professor de Kock talked about it, but my connectivity was odd, so I couldn't hear much. But because there's this understanding among legal historians that the most important process of turning the pagans, the Native Americans, in vassals of the Christian kings were through catechesis, were through conversion. But on the research that I'm working on here, research group on sources of law in colonial America, I found a lot of documents of indigenous peoples that were pagans, so that did not wanted to convert themselves, and they had sort of a vassalage relationship with the Portuguese crown, the secular authorities, and even with religious authorities. So, and that's what drove me to study the legal status of those specific nations that were not baptized. And I was hoping I could do a historical introduction, but due to the time, and I forgot to set the alarm. Just 1 second. You can pass the slide, please. I'll be really, no, come back. Yes, the sort of photos, pictures. Here's appearing for me sources of law, but it's the other slide. Which one? The second, the pictures.
For some reason, this is all I get. So is this the correct slide or is something missing?
It appeared for a second, but
you mean this one?
It's okay. Yeah, this one.
That's the third one. Okay.
Oh, I'm so sorry. When the Portuguese arrived, the Brazilian territory was occupied by several indigenous nations, but they were divided generically between those two groups you're seeing sketchy pictures. They were the Tupis and the Tapuyas. This differentiation is followed two criteria. The first criteria was the linguistic one. So the Tupis were the natives that speak a more understandable language, and the other ones were the ones who speak more a less rational language, the Tapuya. So and the Tupis were the ones living in the coast, so was the first protagonist of this encounter between the Europeans and the natives. But as colonization progressed inland, they constructed relations with this other groups, that was the Tapuyas, who lived by what we call sertões, which is inland within the continent. So this second group of Tapuyas, why they are so important, because most of my documents are referring to them, because they were the natives, the nations of Tapuyas were the natives that were more isolated. So there was more pagans among them, less converted natives. So just the short introduction, just so you know, there was just two kinds of groups, and I will be referring most of the time to the Tapuyas. You can pass the next slide, please. So I messed up the I think I've sent you the wrong. Is the second slide? Yeah, because
This one?
order is the second one, the one that I changed it with the third one. So sources of law in the new board. I would like to talk about no, the second. Yes, this sources of law. Yes, exactly. So the Portuguese juridical culture in early modern age was not that different from medieval tradition. So diverse sources of law could share validity concomitantly in a given territory. And since the Portuguese law was a cultural translation of the Brazilian law, was a cultural translation of this Portuguese law, we inherit this medieval background. So the same features that you are familiar with, we have here. And this autonomy to provide specific solutions to local questions here at the colonies, combining with our ethnical diversity, this different cultural background, set up a framework which various actors were able to contribute to the application of the norms and the construction of this legal system, originating a phenomenon that Antonio Manuel Espanha calls the autonomy of colonial law. So although from the legal transfers and this peculiarities there are from the medieval tradition that locals have autonomy to produce use proprium, we can talk about colonial law as an autonomous phenomenon, but we still share the same features as the use community tradition in Europe. So in this cultural environment, the most responsible ones for this diversity was the indigenous peoples. And they posed a challenge, right, for the conquest, because if the Europeans did not find vacant land and if its inhabitants were not the empires of the church, under the empires of the church jurisdictions, then how to justify Iberic domination over the colonies? Well, for a Catholic monarchy such as Portuguese crown, it could only be by catechesis, by missionaries' work, because in that sense, the missionaries had a prominent role in forging the empire and turning the pagans into vassals of this Christian king, while at the same time they were asserting the political influence of the church in both sides of the Atlantic, and a political influence that shaped our legal culture. And well, of course, the main challenge of catechism and this process of turning the pagans into Christians and vassals of the king was the differences between all actors of this process. So in that situation, canon law and moral theology were often found not to be adequate for the success of the catechesis itself and the subsequent pastoral work that sought to guide and control the natives' lives. So a lot of rules were changed and exceptions were made, and so this is how our juridical culture, our particularities were being built. For instance, by Canon Law, marriage was forbidden if the couple shared consanguinity up to the 4th degree. It is a requirement, was unproblematic in Europe, but here it's unapplicable. So exceptions were made to the second degree and with other relatives that were not by blood, connected by blood. So, but these decisions on exception, the law, etc., were not taken solely local. As the Jesuits, they have a long tradition of communicating, and it was common to consult canonists from the Iberian universities regarding local problems that were rising from the implementation of ecclesiastical normativity. And every time they were constant to them, it was influencing the creation of new materials for the School of Salamanca and for Brazilian context. So one of which it was mentioned, it was the Manual de Confessores by Martin Dias Piqueta. He dealt with a lot of important questions regarding Indian slavers, like the sale of oneself. Well, so reversely, the influence that the missionaries had back on Salamanca was also very important, and it influenced a more ample debate that involved religious and secular authorities, and those schools, the theologians that we are talking about here, especially from Salamanca, but also from Coimbra and Évora, because they were teaching. I mean, someone could be graduated in Salamanca and then go to Coimbra and Évora, and so they share the same culture. But what were the scholars' opinions on the navies' legal status? Right? You can pass the slide, please, Nina. In early modern age, following this medieval tradition, humans and non-humans entities were legally categorized according to the position with the natural order, right, of the cosmos. So it was for the use community tradition, the frontiers between humans and things seems kind of blurred, but that was not the case for the scholars of Salamanca and the intellectual movement known as Second Scholastic. Just by the 15th century, it was a consensus among them that as God had created the world for man, only man had genuine dominion. So man and non-human things were already divided by their capability of the rational capability, their power to reason, and so on. And one of the most important jurists to assert that was Domingo de Soto in the 16th century. And while he expressed his opinions that only men had dominion, only men had legal capacity, only men have personhood, he did it in a way to show how respectful the opposite opinion was on the jus communis tradition. So, of course, it was not a consensus, but was the dominant perspective, at least with respect to indigenous peoples here in Portuguese America, because of the influence of these theologians from Salamanca. So why the concept of dominion is so important? Because there are two parts of the same concept. The dominium rerum is the ownership of things, and the dominium sui is the ownership that a person has over his own body and over his skills. So a slave, of course, it doesn't have dominium sui. So to identify if Indians, the Native Americans, were natural slaves, as in the Aristotelic theory of natural slavery, the barbarians. The first thing to identify is that they were humans. For the Salamanca scholars, they were humans because they shared the same rational capacity as their masters. So if they were humans, they had dominion over themselves and over their body, so they could not be enslaved by natural law, born slaves. So the most influential theologians and jurists in this theoretical debate was Francisco de Vitória, Domingo de Soto, and later the Jesuits Francisco Soares and Luís de Molina. And Luis Molina was the one most influential here in Portuguese America because he lectured in Coimbra for almost 30 decades, and so he was often quoted at the courts, at the King's Council. So his theory really impacted the Portuguese legislation. And so he was a Jesuit, so all other Jesuits are also following his teachings. And he doesn't change much from what Francisco also. He doesn't accept the theory, Aristotelic theory of natural slavery, but of course they were in accordance with other titles for slavery, titles from the Ius Gentil and Ius Civili, like just war, and like selling oneself, or like a punishment for the substitution of the death penalty for some crimes, like crimes against the king. And so he accepted titles of slavery of free men, naturally born free men, in those conditions that they have reverberated here at the other side of the Atlantic, especially because Molina was, the great breakthrough of his work was his empirical concern. He was always concerned with understand how slavery is being conducted in different parts of the Portuguese Empire, in Africa and Asia. So he even offers the person who's reading his book guidelines to identify if the title he obtained, the enslaved person he obtained, was legitimately enslaved or not, based on this. For instance, in China, if you acquire as a Chinese slave, the title was that he sold himself. Probably this title was forged because they were not in miserable conditions there. Diversely, what happens in India. So if someone sells himself in India, probably that's veridical. That's what probably happened. So your title isn't forged. So that's the great innovation of his theory. There's really great concern with reality, and that's why he made such a great impact among missionaries and judges and other councils of the king. And well, just to keep short, that I'm just seeing my time is about to end, and I will show you how these theories impacted in Portuguese America on the norms enacted by the Portuguese crown. You can pass the slide, please. So consider that in Portuguese America, the Jesuits were the mainly responsible for the tutelage of the Indians, of the natives. In practice, they were in charge of the natives' workforce, and they were acting as mediators between the colonies and the natives. And of course, this raised many disputes, and eventually they were expelled for good of the Brazil, but they were expelled many times in different locations. So it was a really chaotic relation between the Jesuits and the colonies of some parts of Brazil, because most of the economical pole of Brazil, the northwest, was dependent on the sugar mill plantation. So they used African workforce. So they were not trying to enslave, but other parts like north and south really rely on their workforce. But according to the major liberty acts enacted by the crown in 69, 6080, 1755, all natives were born free. They were men and they were free men, whether they were Christian or whether they were pagans. There was no distinction there. And as a freedman, they had dominion over themselves and over their land and over their workforce. So their work should be paid, and they were entitled of resting and all those, as if they were European peasants. Despite that, the law recognized two circumstances that could legitimize captivity. Those circumstances are in accordance with the Salmantine scholars' theories. And the styles were the causes of just war, and what they call rescues. So according to the Portuguese legislation, hostility was the cause for just war. Though if the natives were rebelling against local authorities or acted with violence against the king's vessels, then the king or the local government should declare war to exterminate and capture them. But only when negotiations of peace have failed, because it was really important to have them as allies and not as slaves, or, I mean, at least for the authorities, not for some colonies. And another cause for just war was the impediment of missionaries' activities. So although the Indians could not be forced to accept the Christian faith, they could not embarrass the preaching and the catechesis and the missionaries' work. So if they do so, it was a cause for just war, and they could be captured as slaves. And it is interesting because the Jesuits that first arrived here, they were in favor of forced conversion, but the king never enacted any normative that would force them to accept the Christian faith. So just going in the same direction as Luigi Molina did. The other legally recognized cause for captivity, known as rescues, we call resgates in Portuguese, was the purchase of a already enslaved person. So the colonists would go into the woods and say that they were capturing people that were already enslaved, that they bought them, they were going to be eaten. So in that case, they could be enslaved. But as there was this awareness that most of those situations were actually forged, there was a process that have to verify each title. If each native that was captured had to go through this process of verifying the legitimacy of his captivity. But it would never go that way entirely, as one important Jesuit here in Portuguese America reported the king in the year of 1655, they capture a sort of amount of natives, but they only declare 20%. So most of the natives were illicit capture, illicit enslaved. So, well, in practice, all those attempts to prevent enslavement of the natives were not sufficient to prevent illegality. So that is why I found on the archives so many prosecution processes against people that have forged just war or forged illicit rescues. And so there was this attempt to prevent them from happening. So, and just to conclude, because I have, that's my time largely, I'm so sorry. One of the most important features of these norms, this normative corpus that I found, is that they do not make much distinctions between Christians and pagans, but the distinctions were between allies and enemies. So it was possible to identify two indigenous policies of the crown: freedom for allies and Christian natives, and death and captivity for the rebel ones after negotiation failed. So in order to be an ally, the non-converted Indians, mostly the Tapuyas, should collaborate with colonial authorities. And this collaboration took some different forms, from sharing geographic knowledge to frontiers defense, moving their village to specific territories that were interest for the crown, because what's create a barrier between the colonies and enemies nations. And they had to help with militia force against internal enemy and even external enemies. But what were the internal enemies? Mostly rebel natives, but also fugitive African slaves. So the Papuyas that had this geographical knowledge of inland were really important for the Portuguese colonists to recover their slaves, the African slaves that were safe, looking for safety within the continent. And external enemies, there's a period that the Northwest Brazil was occupied by the Dutch, and the Tapuyas also had an important role on expelling the Dutch from here. So as I like, they could have created their freedom while they were also preserving their culture. And by behaving peacefully and cooperative, they did not have to abandon their faith and convert themselves. And yet they could make claims to the king and be in this sort of vassalage regime that I don't know if I can officially speak as a vassalage regime. For instance, and just to conclude, I have found different peace treaties, two different peace treaties I have worked with from rebel natives. They, instead of being captured or murdered, they were offered and they accepted. And for one group, there was no condition of conversion, and for the other group, there was the condition of conversion. So I think not only the laws that came from Portugal established this policy, but also the local practices. If the governor was more Catholic, I mean, he could insert this condition, or if he was more faithful to the law, and then he would expressly declare that they had to collaborate, but they were entitled to preserve their religion, their culture, and so on. So that's what I had seen so far, but I still have a lot of documental sources to go through. This paper just is more like a theoretical background for a PhD research that I'm trying to conduct. So that's all. And I would like to finish my presentation saying that I'm really grateful for the opportunity and congratulations, thank you the attention, and sorry because I was today is raining heavily here and it affected me because it was the power was often going off and I was going without energy. It was on and off, so it impacted me. I'm sorry for that, but I hope you get the idea of what was to be a pagan in Portuguese America.
Thank you, Sarah. I'm stopping the sharing now. So I'm opening the discussion. Feel free to either raise your hand in the app if you can see the button in the bottom. If not, you can just turn on your microphone and speak up, or you can ask a question in the chat. We had a hand somewhere after the first presentation, I think, but I don't know if it was a question that's still present. So while people are thinking, I'm going to ask, well, two questions essentially to Veronika and to Sarah, though the first question relates around a similar subject, so that's why I'm connecting it. Essentially, it's the question of whether something was done formally with some sort of clarification, with a reason given, or just a strange practice tolerated informally. So in the case of Veronika's presentation, you mentioned that many of those convicted did not even pay half the punishment that they were granted, that many were released from prison very quickly. So was that some sort of formal dispensation? And if yes, what reasons were given for such alleviation of the punishment? Or was it some sort of informal tolerance? And again, in Sarah's case, you said that exceptions were made for the consanguinity rule, that the limit was reduced because it was inappropriate for the local environment, but was that done formally and with what reasoning, if yes, and if not, how was it tolerated in practice? So whichever of you is ready first.
Look, I can start answering. Thank you very much. It is a really good question, and I think the answer is both, because the source doesn't really directly address these. Some of the enrollments are very short, but there are cases when we see that the person was released out of the prison, and this is more in cases of theft, let's say, from the order of the Archbishop. So they don't really, unfortunately, say why, but I would here connect it to the informal intolerance of it, especially in case of the moral delicts. Well, I think because then the problem with breaching celibate is a question very old, and since the synods early on, before it was mentioned. So I think that when the Archbishop created the office, there was a good intention, but then when they started to investigate, they realized that the problem is like widespread, and that if they really excommunicated all of the priests that had concubines and women with them, it would also be very much problem for the administrative structure to replace them, and etc. etc. So I would say it's more of the informal tolerance, but we can also see some of the dispenses given by the Archbishop or the Corrector himself, but unfortunately it doesn't really explain why. So I hope that answered the question a little bit.
Thank you. Now Sarah, and after that we'll have Mikolai's question and Sophia's question in the chat.
So regarding the marriage question, the exception of degree, it started with an exception and with consults to canonies, but eventually became a papal bull. So it was quickly solved with no problem. So it was applied. And I would like to enjoy the opportunity to speak regarding Vitoria's research, because my dissertation thesis was about sacrilegious sons of priests in Portuguese America. So it's the same thing. It was the same thing here in colonial Brazil. You know, there was this attempt to avoid scandal. So many of the priests were actual vicars. So they were ecclesiastical judges, and they had concubines and they had sons. So there's this, even the social tolerance of the colonial society, but also secular ecclesiastical tolerance. And sometimes even justifications that, he abandoned the concubine, and he paid fines. So it's interesting because it's just a century that's separate. I mean, my research was for the 17th century, and I see the same features here. That's just, I would like to add that.
Thank you. So now we have a question from Mikolai. Please go ahead.
Yeah, I have a question for Veronika about the, especially the recidivists, why they were not charged, or were only conditionally charged, punished. And what was the crime of dispute? It was on the chart with the cases that with which the corrector has intervened.
Thank you very much. So as to the first question about the recidivism, well, I don't really know the answer. I have some theories, and it is linked to what I answered before, that if they actually charge all of them, and if they excommunicated everyone for playing dice, etc., that would mean some of the administrative problems, so they chose to be more tolerant, because the problems with concubines and playing dice had been, I would say, rooted in the society before. So that's why they chose to be more tolerant. Although I perceive the problem that they actually ruled some norms that they didn't follow. But unfortunately, I don't have exact answer, because the source doesn't really say. But if that's at least a little bit sufficient. And to the second, because the crimes was just 10%, the theft, robbery, and the problem with dispute, because the book itself, the judicial book, and I spoke about the more of a administrative agenda. The book served also as a general enrollments, meaning the question you were asking. So when they wanted to get their dispute resolved, they named their arbiter, and they came to the corrector to write it down. So if anyone does not, after the judgment of the arbiter, if one of the parties don't subject themselves to the ruling, they will have to pay a fine. So this was more to secure the outcome of the dispute. So it was more of a general register, the book also. So I'm sorry for the confusion if it looked like all of them were crimes. No, the crimes, the theft, murders were just in 10%, and otherwise it was more of a general register problems. So I hope that answered your question a little bit.
Thank you. Yes, it did. And also for Agata, why do we have now what are the origins of the foreseeing or forward going contracts that we have now, and in the Western law, because the concept of seeing the contract only at the end of the whole process of, for example, selling some flowers, as you have mentioned, is really more gives really more freedom that the contracts which sometimes the written contract that which sometimes can't be reversed. We have nowadays some no punishment reversal periods, I would say, but it isn't in all cases. Why do we have this method of contracting?
Thank you for your question. I hope I understood it correctly, and would like to ask you about what specific answer would you like to get. And I would like to be sure I understood your question correctly. So you would like to ask, why do we perceive contracts that are based on promises in the so-called Western legal tradition to be legally binding? Is that your question?
Yeah, and why do we bind them sometimes much earlier than the acts occur? Yeah.
Thank you. It's a really good question, and it's actually the answer to that question will be also the answer to what a contract in the Western legal tradition actually is. A contract is an agreement which creates a binding obligation between parties to perform or not perform some actions in the future. So it limits our possibility to choose what we will do in the future. Let's take the example of flowers once again. If I promise to sell the flowers and you promise to buy those flowers, the property is not transferred. The flowers still remain mine until the moment you actually take them and I get the money. And in the European legal tradition, the mere promise is said to be legally enforceable because it roots from the biblical rule not to lie and not to take oaths you cannot fulfill. So an oath and a word has a lot of meaning in the law that has been shaped by Christianity, more or less by canon law and the civil law in medieval times and done after the Enlightenment. So although now our legal systems are mainly atheistic or not trying to make one religious stand above the others, they are still rooted in the biblical principle of keeping one's promises. So we may create a binding obligation just by saying, just by words, because the words convert the meaning. And this is the reasoning that the obligation can be legally enforced, although it has not happened. And let's look at the market practice. There are many situations in which the stability of contract and the stability of one's promise is extremely important for the trade. Let's assume that an entrepreneur is willing to purchase some goods, for example, for his restaurant. And he has to make a plan for financing the restaurant, and he has to be sure that the promise that the fresh vegetables will be delivered on time will become true. In the Jewish law, the promises are also binding, but they're binding more morally than legally. Only some of them are legally enforceable. And the legal enforceability begins with the act of the transition of ownership and the act of acquisition called kinyan. I hope it answered your question.
Yeah, it was about this that you mentioned. Thank you very much.
So we had two questions in the chat from Sofia Lekis. For some reason, some people don't have the option to chat to everyone, so I'm copying, and if that's the case for anyone else, feel free to chat to me and I'll copy it to everyone and I'll read them out loud just in case. So the first one is for Veronika. She says, first of all, I would like to congratulate you on giving an extremely interesting presentation. I would like to know, when did the office of the Corrector of the Clergy cease to exist, and what were the reasons behind its end of existence? And for Agata, Sofia says that it's wonderful research. She would like to comment on the analogy between the kinyan and some similar concepts in other legal traditions, such as the real obligations in Roman law, as well as the feudal relationship establishment in the Frankish kingdom, where a symbol of the property, investiture, had to be given in order for the obligation to be valid. So go ahead. Veronika first, I presume.
Yes, all right. Thank you very much. So in the judicial book that I described, we have some charts and enrollments that were made later. So we know that the office continued after 1410 up until, let's say, 1420, because in 1420 occurred the Hussite Revolution, the Hussite Wars, so one of the fundamental historical events of Bohemian history, which was a conflict between the Hussites and the Catholic Church, and they wanted Reformation, etc., etc. And so at that time, the offices didn't, the administrative structure of the Catholic Church didn't work at all. So the Corrector ceased to exist before the year 1420. It is also an interesting question why it wasn't re-elected, or why it wasn't refounded in the time of the actual Reformation after, right? If he was the moral judge, if he was the reformative source, but unfortunately, I also don't really possess answer to this. But it's an interesting topic. So before 1420 would be the answer. Thank you.
Thank you. And Sofia says thank you. And Agata, would you like to comment something on Sofia's comment?
Thank you. I'm very grateful for support and those interesting facts you mentioned. It is definitely true that there's a similar case with real obligations in Roman law. For example, let's take those well talked about flowers. If I transfer the ownership then the obligation is actually bound. We have a merchandise only when we transfer the ownership. However, there is in the Roman law, there was also the institution of a verbal obligation. For example, an obligation to sell would be a different obligation than the actual merchandise. So let's imagine our situation that we agree on the price and that I promise to sell the flowers and you promise to buy them for the agreed price. We may have witnesses or we may not have witnesses. And we may have two different obligations. First, we may be obliged to keep our promises just as a verbal agreement. It's the same kind of obligation as an obligation to promise to borrow a book. However, the obligation to sell and to buy only arises with the transfer of property, and that is what you described. It's a bit different in Jewish law, although it has some, although I hope I stress this enough in my presentation, that the Jewish contract law and the so-called European contract law were basically very similar up to the 11th and 12th century. For example, even in some regions, even to the 13th century. There are documents from the 13th century England which describe the manner of selling wheat on the market in the same way as it is described in Jewish documents from 1300 years before. So it's really interesting to see that those two legal systems have the same roots. However, they started to differ. And the Roman analogy is also quite good and because the Roman law is supposed to be the basis of the future freedom of contract. Although it's worth remembering that the freedom of contract did not exist in Roman law. Contracts were largely limited. There was a closed number of contracts that could be taken. And we have to remember that the freedom of contract is a rather modern institution, which was largely shaped by canon law and Puritans in the common law countries, and mainly by the Enlightenment and the natural theory states. You also mentioned some Frankish kingdom and its feudal relationship. It definitely is this way. And I'd like to say something what you might all find interesting, that the Sinaitic covenant between Moses and God is thought to be described as the way that the Caesarean covenants were made in those times. In the Hittic period, the covenants between feudal lords and vassals were very similar to the covenant that God made with Moses, because they were also binding to the third party, which is a pretty new example to the Roman law tradition, which did not make a third party liable for the breach of contract, because its will was not present in when the contract was made. However, later it evolved to make it a bit more flexible, and it's worth remembering that those two legal traditions stem from a different perspective of who can be bound by contract. In Jewish tradition, a third-party obligation is extremely important, because without a third-party obligation, there would be no Jewish religious identity. The Jews are protected by God because Moses made a covenant with God, who said that if your descendants will do what I told them to do, we will keep the covenant going. So the third-party obligation is the basis of Judaism, and it took a few centuries, if not a millennium, for the so-called Western legal tradition to develop the ability of a third party to take part in a contract. So thank you again for your information. I would like to read a bit more about it.
Sophia is answering. I'll paste it to everyone. So she says, of course, not all institutes of Roman law obligations are similar to Jewish ones. I just saw some similarities, but I agree with you. There are also significant differences between the two systems. As for the Frankish law, I absolutely agree. It is very interesting how similar legal systems can be, even though they seem very different at a first glance. Once again, congratulations on your research. Thank you for your detailed response. We have a question from Jan Planjik. and after that, maybe it would be time to end the discussion because we are already behind schedule. But Jan, do go ahead.
Yes, so congratulations to everybody. And I have a question for Agata again. Do you know anything about how does the traditional Jewish attitude to contractual law affect the contractual law in the state of Israel?
Well, unfortunately, my studies might focus on the classical Talmudic law because actually the Israel's system of law is very complex. It is based on, yeah, that's why I'm not particularly sure how it works currently. Because now, I think that to understand the Israel system of civil law, we'll have to understand not only Talmudic law, but different schools of interpretation, both the Orthodox and the non-Orthodox, which totally differ. For example, Bat Mitzvah is not an Orthodox institution, and it's the main institution of non-Orthodox for non-Orthodox Jews, because well, if we say that the Jewish identity is based on the idea of duty and the acquisition of duty to be obliged by all norms that are written in the Torah makes someone a valid member of a community, that we can say from a Western perspective that women can feel excluded from this because they are not able to take part in some of the rituals. And there is very interesting dispute, because when we from the so-called Western perspective are used to thinking about rights, for example, right to participate in a religious ritual. And from our perspective, it may seem that excluding women from some of the rituals may be a form of discrimination. However, the Orthodox Jews argue that it's not a discrimination because it's based on duties. There is no such thing as a right to participate in religious rituals because it's not for fun. It's a very serious matter. It is a duty. And everyone who is able to participate must do it. So they traditionally argue that that women also have another obligations, another duties usually made for their families, for their children. Putting another duty of them, which is a pretty harsh obligation of participation in some religious rituals, would be too much. So in current Israel, we have two ways of thinking on the Talmud itself, at least two ones. I'm talking only about the most extreme ones because there is a whole array of schools in between. And it's only the classical halachic law. And we have to remember that the legal system of Israel is also very strongly influenced by continental lawyers, because many of the lawyers who made the Israeli system of law fled from Germany and other countries of civil law after the Second World War. And however, there was a great minority of Jews in the US and English-speaking countries. So they have a very special kind of a mixed jurisdiction system in which we may say that the private law is not codified in the way it is in the civil law countries. For example, there are different codes for marriage law depending on the religion of a person in Israel. So I'm not an expert in, unfortunately, in Israeli law, and it's definitely more complex. I wanted to focus on the classical religious tradition because I believe it will make me able to understand what will happen in the future, and it's happening right now in the Israeli law. I hope I answered your question as well as I could.
Yes, thank you very much.
Thank you. And if I just may ask a really short question to Alexis. I'm sorry if this is a basic thing because I'm not an expert on the subject, but I was really interested in the books you mentioned that were written in the vernacular language and thus meant for a broader public. When did this tradition of writing them in the vernacular show up, and did it maybe spread further than Spain?
Well, actually, the very first book only dedicated to casuistry of the School of Salamanca was written by Martin de Espiricueta, so it was Manual de Conferencias Penitentes that told you about. Its first edition was published about I think 1550 in Portugal because Martin Spilqueta was sent there by the emperor, so Charles V. I don't know exactly how to say it in English, at the demand of the King of Portugal. So the very first edition of the very first book of casual history of the School of Salamanca was published in Portuguese around 1550. And then most of the books were written directly in Spanish and at the destination of penitents in Spain itself. So they were written in Spanish. But re-editions were then printed afterwards, mainly in Rome and a lot also in the Netherlands, notably Antwerp and Leuven. So mainly, yes, it was Martin Spilqueta first, and all the books were mainly published first in vernacular language for the Iberic Peninsula, so Portuguese and Spain, and then in Latin for mainly Italy and the Netherlands.
Nina, I'm so sorry. Just to add something, I'm posting the website here so you can see Martin Spilqueta in Spanish. They have a lot of books from this tradition that Alexis talked about, digitalized by the Max Planck Institute.
Yes, they are.
Yeah, I'm sending the website here. So
Wonderful.
I don't know how to send to everyone, but I sent
For
to you
some
privately.
reason, it's a bug. Some people can check and some not. I'm not sure whether it depends on your app version, but I just reposted it to everyone. So thank you all. Those were 4 wonderful presentations. We are taking a 10-minute break now and proceeding to the 5th session. We have one person missing there, or rather unable to attend, so hopefully by the next session we'll catch up to the schedule. See you in 10 minutes.
Thank you very much.